Welcome to Compliance Monk. In the unending saga of industry and production, responsibility and safety takes center stage. The compelling tale of J.K. Industries Limited versus the Chief Inspector of Fisheries and Boilers in 1996 serves as a stark reminder of this fact. The Supreme Court, in its wisdom, observed that the legislature, through the Amending Act of 1987, sought to instill a sense of responsibility in those at the helm of factory affairs. The goal? To ensure proper maintenance and safety measures in factories. This story begins with the legislature's intent to foster vigilance and responsiveness among company directors. The fear of penalty and punishment was seen as a potent catalyst for directors to fulfill their obligations, particularly concerning the safety and welfare of the workers. Proviso 2 was introduced as a mandatory measure to prevent directors from evading liability for breaches and defaults in the factory by using other employees as shields. The Supreme Court held that a company owning or running a factory holds ultimate control over its affairs through its directors. Even if a board resolution suggests that an officer or employee other than a director has ultimate control, it's merely a ruse. The ultimate control cannot be transferred from the company to one of its employees or officers, barring a complete transfer of the control of the factory affairs. The term occupier in the context of a factory, when owned by a company, must necessarily refer to any of its directors. And such an occupier cannot be any other employee of the company or the factory. This interpretation of occupier applies to all provisions of the Act where the term is used, not just for Section 7 or Section 7A of the Factories Act. The court further held that Proviso 2 doesn't overstep the main provision of Section 2(n). In fact, there's no conflict between the two. When read harmoniously, the occupier of a factory owned by a company would mean any one of the directors who has ultimate control over the factory affairs. And where no such director has been identified, the inspector of factories may initiate proceedings against any one of the directors as the deemed occupier. It was further clarified that there's nothing unreasonable about holding a director of a company accountable for compliance with the provisions of the Act and the rules made thereunder. If there's a contravention under the Act or an offence is committed, the notified director, or in the absence of notification, any one of the directors, shall be prosecuted and liable to be punished as the deemed occupier. This provision ensures that any director, including an additional director, can be considered or designated as occupier. This case underscores the importance of responsibility and safety in factories. It sends a clear message to those in control: the welfare of the workers and the maintenance of the factory are paramount. The law does not condone evasion of liability, and ultimate control means ultimate responsibility.